copyright attorney in Santiago, Chile. It's very interesting to me, the difference, not necessarily in the copyright between our two systems, but just the difference between the common law and the civil law. Mm-hmm. So in the United States, we have the common law system. Everything is based on precedents, not everything, but statutes come first, obviously. But you have within just cases, the judiciary essentially makes law through determining cases, and then there's a presidential system that uses the concept of stare decisis. But in the Chilean system, following the civil law, each case largely has no impact on every other case that comes. So it's interesting to me because when I think about different cases that have happened in the copyright law in the United States, I'm like, oh, this situation leads to an understanding of the next situation. But even if you had worked on a case, the next case could come out completely different because there is no precedential system, right?
Well, the interesting thing about how it works in the US is that when you have a practical problem that you have to resolve, you usually analyze it a lot to see how you resolve it. And that creates a certain depth of how the system works. I mean, there are many aspects that judges have been thinking about in a very profound way, and also in a very practical way to see how conflicts are resolved. And that, as you say, forms then part of what rules for the future. But here you have just this piece of law that you have to dive into every time. And of course, there are going to be practical cases that they have a certain influence. It's not really an island in the sense that the next case could be entirely different. I think judges will consider to a certain extent how other judges have resolved matters. But it's just that. It's something you will look at, and there is no obligation for the judge to follow the same criteria. And actually, it happens with a certain frequency that one case is decided in a different way. And there's also probably not, because the law is what it is, and it's not developing through cases, you don't really add that much of depth to the discussion. You just have this one text to refer to, and that can be good from some perspectives, but from others, it lacks that live development of which makes the law richer, I guess, with every new case.
I wanted to ask, as we're wrapping up, a little bit about what you see in the copyright system around you and maybe what suggestions you would have for making it better. For example, you had mentioned that maybe 70 years after the death of the author for copyright is a little bit too long. So maybe if you wanted to talk a little bit about that, some of the policy considerations around what an appropriate amount of time would be, and then also any other thoughts you have on the system and what could make it better, and a better environment for people who are creating things or corporations, or for the creativity and the culture itself.
Yeah, well, the duration is an aspect that, well, of course, there are publishing companies and other corporations who will try to retain the rights as long as they can. But from another perspective, it is true that there are many cultural works that should be perhaps part of common heritage, and from that point of view, it would contribute perhaps more to our development if that would be more accessible in terms of price also. But perhaps the main improvement that could be done here is to make the copyright law more nuanced, perhaps, or to make better distinctions between the different kinds of media that we have now. I think it is still too much based on traditional media, on traditional forms of publishing things and distributing things, and traditional forms of creation. And there are many challenges considering today's digital world that simply cannot be addressed by the law as it is now. From that point of view, there is still a lot of work to do. And I think there is also, and that was the advantage I was talking about of how the U.S. system works. I mean, if every new case where these developments that modern technology or whatever throws at you, if you're dealing with that, and that then becomes part of what the system or the legal environment that you deal with, well, that helps to keep the system up to date. And I think that is a little bit missing in the law as well. I mean, there are simply so many aspects of copyright that it is very hard to make general rules that will cover all these different situations that you will encounter, particularly considering that copyright law refers to many different kind of creations, from software to sculptures or whatever, and they really have very little in common in many cases.
Great. Well, thank you so much for speaking with me. I really appreciate it.
Thank you, David.
And this is I've learned a lot.
I've learned a lot too, I must say. It's also, I was, as I said when we were talking a while ago, it's interesting for me also to hear about the US system, and to compare how the systems work is actually very, very helpful for getting a better sense of what your own system is about. So thank you very much.
This has been a production of UC3P. Big thanks to the Law School, University of Chicago Law School's International Immersion Program for funding my trip to Chile. And also big thanks to Oscar Zarhi for introducing me to Klaus Krebs. I really appreciate it. Please make sure to listen, subscribe, rate, and share all of our podcasts. We really appreciate it, and we really appreciate you. Thank you for listening.
Hi again, and thanks for listening to this episode of UC3P. Special thanks to Klaus Krebs for a fascinating conversation, and to David Raban for recording and producing this episode. Also, a big thanks to the Law School's International Immersion Program for funding David's research in Chile. I, Susan Paykin, edited this episode. Don't forget to listen, subscribe, rate, and share this episode and other new UC3P releases. Thanks again, enjoy the winter break, and stay tuned for more next week from UC3P.